Have you ever been to a convention or a fan event of some sort and seen fan art being sold and you thought maybe, wait a second, doesn't Nintendo own that property or some other company? How is it that a person has licensed, or how are they able to create art on this topic? Isn't that illegal? Or if it's not, what rights do I have to even buy it in the first place? This is Mile High Pokemon. Today we're talking about fan art, its legality, and copyright more generally. Hopefully by the end of this you'll have a better sense of how copyright works, where it applies, and in your own life deciding what's a violation and what isn't. So before we start, as always, I'm a lawyer, but I'm not your lawyer, and this isn't legal advice. When you come to copyright-specific issues, it's very fact-specific, and the same answers will not always apply in all situations. So don't rely on what I tell you. If you have your own issues, go see a lawyer. This is just my interpretation of how the law works. And by the way, I have my own views on how copyright should be, but I'm mostly covering today how it works in reality and not just my own personal views. So first, what qualifies for copyright? Well, copyright is a type of intellectual property. It's different than trademark, patent, and trade secret. Those are the other main types. And it's something that's fixed in a tangible medium of expression. So it can't be an idea. It can't be something you think up. It has to be on something. Either it could be music, painting, sculpture, recordings, dance even, as long as it's recorded in some function. But again, it can't be an idea. So it can't be a joke, for example. You could write a joke book, but jokes are famously not copyrightable. You can't copyright a genre or even really a style. Juries can be unpredictable, but generally in the law, you can't, have a whole monopoly on just one genre that nobody else can intervene with. That doesn't work. So any work that qualifies for copyright must be original. That means two things. First off, it must be have a modicum of creativity. This is a really low bar, pretty much any amount of independent thought. And second of all, it must be independent creation. So it can't be copied from something else. You can't use another copyrighted work generally. So it has to be unique. Where does this come from? Well, it comes from the Constitution itself. It's actually, a lot of people don't know this, but essentially there's a part of the Constitution that says that Congress specifically will have the power to pass copyright laws to incentivize the creation of new things. So Congress itself can decide how long the copyright term is, and it's empowered to do so by the Constitution. It's like an exception to the First Amendment, essentially. So what rights do copyright owners have? Well, you have the right to reproduce, to share, to distribute, to perform, all these other things with the right. And it also gives you the right to limit the use of your work by other people, generally. And there are exceptions to that we'll talk about. This protection generally lasts for 70 years for the average person, or 95 years for corporations or anonymous authors from the date of creation. So 70 years after the death of the author, or 95 years from creation. And the other thing is that copyrights are automatic. As soon as you create the work, you have it. You don't technically have to register it. You can register it to get certain benefits, like being able to sue someone, but you don't have to do anything special to get a copyright. Once you create the work, you have it inherently. So why does copyright exist? Well, as I talked about, it incentivizes new works. The idea is that, well, if people know they're going to get a great payout if they create masterful works that they can sell, they'll be more incentivized to create them. In my view, that's not always the case. So a little while ago, pretty much at the urging of Disney and other big corporations, Congress changed the copyright term from 70 years to 90 years or 95 years, just depending. So they added 20 years essentially to the copyright terms. And to me, that doesn't incentivize any new work for two reasons. First off, because if I know if I create something, I'll have a copyright for 70 years, and then it changes to 90 years, I don't feel any greater incentive. Like 70 years is still a lot of time to have possession and ownership of a copyright. I don't think 90 years versus 70 years really makes that big of a difference. And second of all, they retroactively applied this. This was even crazier. So essentially, people who created art, like Disney creating Mickey Mouse in the 30s or 40s, whenever it was, he thought he would get, say, 50 years or 70 years of production. I don't remember what the time period was then. So there's no extra incentive to create if you're just going to retroactively extend the period of time for which copyright applies. So like Disney, when he created Mickey Mouse, didn't know that 70 years later his copyright would be extended later. So he made his art already thinking that he would have it in possession for a set period of time, and it doesn't make sense to extend the period of time if it's not actually going to incentivize any new creation. That's my personal view. Also, as you make copyright stronger, you get certain difficult situations like anonymous works. So a lot of the time, researchers, for example, want to use anonymous works, or other people find anonymous works, but they still have a copyright from when they were created. And if you don't know who created it, nobody is able to give permission to reprint it or reuse it, essentially. And it's like a lost work, in essence. As I said, one of the counterpoints is that it essentially helps the rich, and really those that amass the largest number of copyrighted works that are most successful are going to benefit the most. Frequently, regular artists are not the ones making loads of money off their own copyrights, right? The indie artists, say. One other thing is that there's an exception to copyright. It's the first sale doctrine. Essentially, if I buy a book, it's the first print, I buy the book and then I resell it or lend it to someone, I'm not breaking copyright. Even though I'm literally distributing a copyrighted piece of work without permission, it's still copyrighted. So this is just how essentially movie rentals work, how other sorts of rental programs work in reselling, etc. So far, we don't have the ability to resell digital works in the US, but in the EU, their rights in this era, or in this sector, are expanding. And from what I understand, Steam, for example, I think has to allow reselling of digital goods to some extent in the EU. So we'll see if that ever comes to America, but that's a statutory thing. So now that we have the basis of copyright, let's go to the very first part, the first sort of example. If you go to a convention and you see merch of a certain type of art, let's say it's a Pokemon poster, and it's literally copied. The art is copied from something Nintendo made, and someone else decided to put it on a poster and sell it. Is that copyright infringement? Yes, this is an easy one, right? It's literally an exact copy. You're copying from a corporation something they themselves made. You know, not just the characters themselves, the entire poster you copied. That is a clear violation of copyright. And it's one of the reasons why licensed goods cost so much more to buy. Because essentially licensed goods have a premium. They're legal. So that one's easy, right? So then the question is, well, is buying bootleg products illegal? What if you didn't know? What if you didn't know and you bought something that was illegally created or distributed? Now you have it hanging up in your house as a poster. Is that illegal? Well, generally, copyright targets distribution and reproduction. Those are those rights we talked about before, the rights of a copyright holder. Interestingly, one of the rights not in the statute about the right you have is possession. So essentially, if you just have simple possession and you're not distributing, you're not reproducing, etc., something that's copyrighted, my understanding is that that's not actually illegal. So if you created a copy, that's different, that's illegal. But if you bought something that was already copied and you didn't know, that's not a violation of copyright, I don't believe, anyway. So now we're going to talk about fair use. This is the thing that so many artists claim, sort of wrongly, as I'll talk about, as an excuse. And I've gone before, just out of curiosity. Maybe there's a part of the law I don't know, where I go to artists at conventions, sometimes say, "Oh, that's cool, you're sending Pokemon gear. How are you doing that? Do you have a license or something like that?" And every time they'll say, "Well, it's fair use." Well, we're going to talk about that now, because it's probably not fair use. So what is fair use? It allows an individual to copy a work of someone else without permission. You're literally copying it. You're not asking, and you're usually allowed to do it for criticism, news reporting, teaching, research. There's like several purposes that are favored. Generally, the copyright must be done for a limited purpose, so you're not taking the entire thing, and for a transformative purpose, so you're not just copying a movie beginning to end, and instead you're using a clip of the movie, say, in another context, to explain something or to make a joke, etc. The four factors of fair use are, first, what's the purpose and character of the use? That is it the purpose is commentary or news reporting or something like that? The nature of the copyrighted work, so what is the original work and what's its purpose that the work exists in? The amount and substantiality used, so did you copy the entire movie or just part of it? And the effect on the potential market or value of the original work. And that's the biggest, the most important. Essentially, is your new work, the fair use, is it competing with the original? That is the most important factor of the four. There's no specific test on how to weigh these. Essentially, a court goes and looks at each one and is like, yeah, it's fair use or it's not, which is why it gets really, there's a lot of gray area here. And we'll talk about some examples. But essentially, it's very difficult to know for sure, in a lot of cases, whether your use is fair use or not. So first, we ask, what is the purpose and character of your use? Is your work commercial in nature or educational in purpose? So are you selling stuff or just to make money? Or is your use educational or for the purpose of commentary, reporting, etc., as we talked about? And is your use transformative? That is, does it have a different meaning or use than the original? And we'll talk about that in a little bit in the context of Andy Warhol, so stay tuned. So question number 2 is the nature of the copyrighted work. Essentially, courts generally give more protection to creative works in fiction than nonfiction informational works. They're generally more protective of things made for the educational market. The reason for that is like, well, if someone already created a lecture series, it's not really fair to let you lift it up, you know, the educational paragraphs they already created, to then reuse it for another educational purpose. Like, that's stealing. You're cannibalizing that market, the educational market. Also, there's greater protection usually for works before the initial publication. Essentially, after you first publish something, your copyright ability or your rights lessen, because after that, fair use is a lot easier to do. But if you have like a diary or a draft of a book, that is far more protected before it actually gets published. The next prong is the amount or substantiality of the work used. Remember, the less you use, the more protected you are. But sometimes you need to use an entire work to make your point. So, for example, if I want to critique a piece of art, like a portrait that someone drew, and I want to critique it, I want to give my own commentary, it's sort of impossible to give my commentary without actually having the entire work in front of me to talk about. So in some cases, you can copy the entire thing. It just depends on your use. Essentially, if you're going to take the very core of the work, though, the heart of the work, as it's called, it's less likely to be fair use unless it's absolutely necessary for your work that you're trying to make, your new work. So once again, to remind you, ideas are not copyrightable, only the fixed pieces of work. So let's say someone writes a non-fiction news article. A piece of news comes out, they write an article. I could copy the information in that article and rewrite it in a different way, paraphrase it, right? It might be plagiarism, but it's not going to be copyright unless I copy it exactly. Finally, the most important factor is what is the effect on the market of the original work. So, for example, if you copy someone's portrait or their song and you redistribute it and you are competing with the original because they would buy your copy instead of theirs, that is far less likely to be fair use. And this obviously matters in the fan art scene, because if what you're selling is competing with the original Pokemon version of it, or whatever hobbyist group you're selling from, or you're selling art from, then that is far less likely to be fair use. So as you can see, it's tricky. Essentially, the core question is your new use competing with the old use? Is it going to hurt the market? The one little caveat I wanted to talk about is new markets. And essentially, it's difficult sometimes to know whether your use of a work is going to cannibalize the original, because maybe the market doesn't yet exist. And think about sampling in hip-hop. So many songs and rap and hip-hop, you'll use clips of other songs in your own, right? You'll string them together in a new way. I think that 50 years ago, this would have been considered a fair use. Essentially, you're only taking a small piece, you're creating something entirely new. But nowadays, because people are afraid they're going to get sued, they, ahead of time, will license the clips from other artists. So they get permission from other artists to use the pieces of their music, they pay them, and now you have a whole market of licensing for little clips. And now, all of a sudden, it's not fair use anymore, because if you were just to steal someone else's clip of music in your own new song, you're now competing with them, or it's also going to be considered to be depriving that song or that artist of their market value, because in any other situation they would get paid for using a clip of their work in sampling. So it's a little confusing, but essentially, because people are afraid they're going to get sued, they'll frequently license things that they don't actually need to pay for, they don't actually need to license, and could be fair use. But when enough people do that, you're creating a new market for a product. So we're going to do a few examples. This is the most recent case, Andy Warhol. I think that the Supreme Court got this wrong. Like, I don't agree with their decision, but I'm going to give you what they said. So the one on the left is a photograph taken by Goldsmith, this photographer. The one on the right is based off that photograph, the painting that Andy Warhol made. So Warhol pretty much licenses his portrait to a magazine. The magazine put his portrait, the painted one, on the front of their magazine. And the photographer sues, saying that she didn't get paid for her use because the painting copied her photo and she didn't get paid. The Supreme Court, Warhol tries to claim fair use. He says this is a transformative work. It's not the same market. Do-do-do-do-do. The photographer wins for two reasons. First off, it wasn't adequately transformative. Essentially, the Warhol painting copied almost exactly the actual outline of the photo that Goldsmith took. Second of all, the court decided that they were competing in the same market, because essentially the magazine in this case paid Warhol to put his portrait at the front of on the front cover, but they could have paid the photographer to put the photographer's photo on the front cover. Photographers all the time get paid for their photos to be in the front of magazines. And the court said that essentially they were competing, that Warhol's work was competing with the original photographers. And this dramatically, I think, reduced the fair use right, because essentially if you're copying and there's any amount of competition between the two works, Supreme Court is going to be pretty skeptical about that, which is unfortunate. They also rejected the version of the transformative use test where we have subjective views about what a work means. So one of the arguments Warhol had is listen, the first was just a photo of Prince, and my portrait was a commentary about consumerism, and it looks completely different. My message was different. And if you are a viewer, you look at them, you get completely different things out of them. And the Supreme Court pretty much said, we're not going to do these aesthetic judgments. We're not going to have judges decide whether their purpose is different enough. We're going to look at, number one, how much they're actually copied, objectively how much they're copied. And number two, are they competitors for each other? Are they going after the same market? And here the answer was yes to both, and that was it. This was illegal. Another example is DVR recording. SCOTUS says, SCOTUS means Supreme Court, this is fair use, because you're not hurting the market for the original broadcast. So the Supreme Court said, well, if you have a DVR recording, that's not something you're supposed to sell to someone else. So it's something you could have theoretically watched anyway on TV when it aired. And if anything, this might actually help the market, because new people who otherwise wouldn't watch the show are now able to watch the show. So they decided that when you do DVR, essentially that isn't hurting the market enough to where this is essentially get a fair use right here. Also, there's this satire song, Two Live Crew's Pretty Woman. I'm not going to have a clip here, but essentially they took the song of someone else, asked first to license it legally. The artist refused. They decided to take the song anyway, and pretty much Weird Al Yankovic lyrics all through the song. So completely changed the lyrics, but the song itself and the chords were exactly the same. Supreme Court says this is satire. It's protected, even though you literally took the entire song and only changed the lyrics. It's still protected because it's satire, and your commentary, the satire itself, couldn't have been made without taking the entire song. In some instances, you need to copy the entire underlying work in order to get your own message out, and in those cases it's more okay to copy. Also, they weren't necessarily competitors, because a satire of a funny, is not really going to compete with the original song if the original song's serious and the satire is funny and unserious, whatever. Also, there's a case about Google and search results, which essentially this company sued, arguing that Google was literally committing infringement through Google image search because you did get thumbnails of all the images on their website. The court said this is fair use too. So this is actually, you know, the last few cases you've seen, there's been some strong fair use cases as well. They said that because it's being used in a transformative way, because essentially instead of looking at the image in your entire screen, you're looking at a database. You've got little images that, yes, have been copied entirely, but it's along with the description, and they're not very big, and there's a bunch of them on a single page, so it's completely different in terms of its use and purpose. Also argued that this could theoretically help websites get additional search traffic, so that it's not going to hurt the market. But honestly, the last few cases I've covered, I don't think really jive with the Warhol case, because the last few cases we've seen here have shown fair use being as a pretty expansive doctrine. And then in the first example with Warhol, like, I don't know, I thought it was a pretty transformative use. I thought that that the Warhol work should have qualified, but in that case, they said that it didn't. So let's talk about fan art. Is it protected? Well, it depends. I mean, your first question is, what copyrighted work are you using? And, well, if you, for example, have artwork about Pikachu and stuff like that, you are literally copying the character, right? So you're using it, the original in its entirety, because characters, fictional ones, are copyrighted, even if you're not taking the exact piece of art. The character itself is copyrightable. So then the second question is really about the market. Like, is your work private? Are you distributing it? And if you're distributing it, are you selling it? Here on this page, I decided to have a bunch of examples of various Charmanders, and we can look at, you know, how infringing they are if you were to, say, sell something like this. Well, of course, on the bottom left, we have OG Charmander. If you sell him himself, you are probably infringing, right? There's no change there. But some of these other ones, you know, might be. Certainly the meme is probably protected because it's, yeah, you take Charmander in his entirety, but you're making a joke. You've got satirical use there. That seems far more likely to be protected. The ultra-realistic Charmanders, I think, are also more likely to be protected because you're not really competing in any sense with the original works. You're doing a commentary about, you know, what Pokemon would look like if they're real. They're essentially very transformative. They look nothing like the original, realistically. Look at the Charmander flipping people off. To me, that's also sort of a satire. I think, honestly, the only edge case here is the, other than the literal copy, is the cute Charmander up above. Simply because I'm not sure it's transformative enough, and I think that Nintendo could probably make an argument that if you sell something with that Charmander, that you're competing against their IP and that they have comparable products, you know? And Nintendo is selling Charmander stickers that are normal, and you're selling one like the cute one up above. I think that they can probably argue that you're cannibalizing the market. Although we don't know for sure because it's a really big gray area. So hopefully with all that, you have a basic sense of how fair use works. In my view, the vast majority of fan art is a clear copyright violation. But if it's a violation and you walk through a convention and everyone's breaking the law, why is it there? Why are people still doing this? Well, I don't think Nintendo cares, right? Or Disney, or whoever, for a few reasons. First off, I don't think they have the manpower to sue every, like, Joe Schmo who's out, you know, at a convention selling shit. That's thousands of people they would have to sue, right? It's sort of funny because Nintendo is considered so litigious, but realistically, I mean, they've been hands-off on all this stuff. They're only, I think, going after the biggest offenders. And so, second of all, usually if they really care, they're going to send you a letter first and tell you to stop doing what you're doing, and you can comply to not get sued. So that's also something. And then finally, a lot of this stuff is good for them in terms of marketing. Why would they shut you down if they're going to get good press and if people are going to, for free, promote their own brands? They don't have a reason to shut it down. And sometimes they will if you if you critique them, like there was a streamer a little while ago who played FIFA and would criticize EA in really like vitriolic ways, and EA said, all right, man, we're not going to let you stream anymore because FIFA's our IP and you're infringing. And in that case, I mean, they wanted to carrot and stick strategy, where if you like are an asshole, we're going to use the stick and not let you stream anymore. As you can tell, though, this gives big corporations a lot of power, because essentially, maybe EA's threshold is very high for banning people, but what if Nintendo's threshold was anything that makes us look bad, and you can no longer sell our stuff, or you can no longer, pirate our IP? That gives them a lot of power. Certainly, you shouldn't be breaking the law also, but if they're going to tolerate it for certain people and not tolerate it in other situations, it's unfortunate that corporations have that much power, I think. I also want to talk about AI briefly, because I actually use some AI art in my PowerPoints. I think it's usually sort of funny. But as you've learned through copyright law, as I've covered, you're really infringing only if you make exact copies. And AI, the vast majority of the time, is not making exact copies. It can sometimes make eerily similar copies, right? And sometimes it actually spews out something that's exactly the same because it's been trained poorly or something like that, or you're asking it to produce something very generic. But if it's producing something that's unique and different than everything that exists already, that's not a copyright violation, right? And so people usually argue, well, they're trained on other people's work, right? So in order to actually get the AI to work, it's been fed a bunch of other copyrighted pieces of art. And that's sort of true, but from what I understand, first off, when you download an AI, it's got no art in it. Like, there's no, like, files, right? So if you download a model, you're not infringing by downloading it. And second of all, from what I understand, when AI goes out, it observes art, more or less, and observes copyrighted things. It doesn't actually, you don't actually need to download it to train your model. I think from what I understand, you can, like, the model is trained on by viewing it. So by going on a website and looking at it, or they have a database or something like that. But the model itself doesn't need to use it in terms of downloading it, the copyrighted material. That's my understanding. And I might be totally wrong. So because of that, I actually don't think there's a copyright violation there. This is a personal opinion. This might be, a little inflammatory, but my view is that it's sort of funny. Some of the people most against AI and thinking that AI is copyright infringement are some of the biggest infringers when it comes to fan art. To me, I believe that, from what I've seen online, is a lot of people who are making fan art and literally pirating Nintendo's properties are the same ones who are very angry about AI being widespread. So I won't get too in depth on it here, but copyright, if it's strong, is almost certainly going to favor big corporations at the end of the day, and not the little guy. So if you're going to be on the side of strong copyright enforcement, like, maybe today it's AI, but tomorrow it'll probably be your little, your little fan art stand at the local convention or whatnot, or your DVR art profile. So that's my little rant. Thanks all for watching. I really appreciate it. If you have any other questions on this topic, feel free to leave them below, or on other related legal questions in terms of the gaming industry, the trading card industry. I'd love to cover them. I'm also going to be doing a video on trademark, because as you know, my profile name is Mile High Pokemon, and I'll cover the legality of that, which is fine because I don't think anyone's going to confuse me for Pokemon, the company itself. But I'll cover some trademark next as well, for those interested. Anyway, if you got this far in the video, definitely like it, because I don't know how else you would have made it 40 minutes or however long it's been. Probably not that long. But thanks everyone again, and have a good night.